In New Orleans, Louisiana, voters elected a man to office. And before he could take that seat, the state eliminated the office he had just won. Not because the voters stayed home, not because the election was disputed. It was because they made a clear choice. And after that choice was made, well, the rules changed. If that sounds familiar, it should, because this isn't just a story about one office. It's a story about power, about history, and about a pattern that America has repeated for generations. The man voters chose was Calvin Duncan. His story is extraordinary. As a young man, Duncan was wrongfully convicted. He spent decades in prison for a crime he didn't commit. While he was incarcerated, he taught himself the law, and he used that knowledge to fight his own conviction. And after he was released, he dedicated his life to helping others who were wrongfully convicted. He became a respected advocate, lecturer, and voice for the criminal justice reform. And in 2026, the people of New Orleans elected him to serve as clerk of criminal district court. He won decisively. The voters had spoken. But before Calvin Duncan could take office, the Louisiana legislature passed a law eliminating the elected criminal district court clerk position in Orleans Parish. Governor Jeff Landry signed it. Supporters said it was about efficiency. It was about consolidating two offices into one. It was about cutting costs. And on paper, that may sound administrative, but the timing is kind of peculiar because this office suddenly became urgent only after the voters had chosen who would hold it. Louisiana has no shortage of urgent problems. We're dealing with healthcare, education, infrastructure, poverty, public safety. We have challenges in all of these areas, and these challenges have been with the state for years. And yet this was the issue that moved with remarkable speed. That doesn't prove motive, but it raises a fair question. Why this office? Why now? Why immediately after this election? When a state has this many long-standing and deep-rooted problems, and this is where the urgency suddenly appears, I think the timing becomes part of the story. Don't you? On May 4th, 2026, Calvin Duncan was sworn into office. For a few brief hours, the voters' choice became reality. But that same day, a federal appeals court put the lower court's ruling on hold. And just like that, the office disappeared again. By the end of his first day, Calvin was no longer serving. The man the voters elected was out. Under the new law, the duties of the criminal district court clerk were transferred to Chelsea Napoleon, the elected clerk of civil district court. She argued that state law made her the lawful clerk of the combined office. but city leaders disagreed. The New Orleans City Council and Mayor Helena Moreno argued that the city charter required a local election to fill the new position. The city council then appointed retired Judge Calvin Johnson as interim clerk. Then, in a twist that felt almost surreal, Johnson named Napoleon as his chief deputy. So, for a moment, 3 different people claimed authority over the same office. The man the voters elected, the official designated by the legislature, and the interim clerk appointed by the city. Then, the Louisiana Supreme Court stepped in and paused the city's actions. So, for now, Chelsea Napoleon remains in place while the legal fight continues. Calvin Duncan won the election. He was sworn in, he reported for work, and by the end of the day, someone else was doing the job. So that raises a question. When voters make a clear choice, why does the state get to take that choice away? To understand why this story feels so familiar, we have to go back. After the Civil War, during Reconstruction, Black political power in the South had expanded dramatically. During this period of time, Black men voted. They won elections, and they held office. And almost immediately, the rules began to change. In 1873, 8 years since the end of slavery, in Colfax, Louisiana, Black citizens defended a courthouse after an election dispute. They had voted, they had won, and then violence came. Dozens were killed. 3 years later, in United States versus Cruikshank, the Supreme Court limited the federal government's ability to protect those citizens. The message was clear. Even if you vote, even if you win, the system may not protect the outcome. The attack on Black political power wasn't limited to laws and violence. History itself was rewritten. Groups like the United Daughters of the Confederacy helped shape school textbooks across the South. Slavery was softened. The Confederacy was romanticized. Reconstruction was portrayed as corruption rather than democratic progress. So generations grew up with a filtered version of history, a version that left out the blueprint, which is why so many people are only now beginning to understand what happened and why current events can feel less like isolated incidents and more like a pattern suddenly coming into focus. In 1965, Congress passed the Voting Rights Act. It was one of the most powerful civil rights laws in American history. It recognized that states with long histories of discrimination kept finding new ways to reduce Black voting power. So Congress created a safeguard called pre-clearance. Certain states, including Louisiana, had to get federal approval before changing voting laws or redrawing district lines. The goal was simple. It was to stop discriminatory changes before they took effect. In 1980, the Supreme Court raised the bar for voting rights cases. In a case called City of Mobile versus Bolden, the court held that plaintiffs had to prove intentional discrimination, not just unequal results, but intent. The case involved the way Mobile, Alabama elected its leaders. In some systems, cities are divided into districts, and each district elects its own representative. But Mobile used an at-large voting system. So instead of neighborhoods electing representatives, the entire city voted for every seat. So even though Black citizens could vote, if white voters consistently voted together, they could still control every seat. Black voters participated, but the structure of the system made it difficult for those votes to translate into representation. Black residents argued that the system consistently produced unequal political outcomes, not because officials openly announced discriminatory motives, but because the structure itself diluted Black political power. Congress understood something important. Modern discrimination rarely introduces itself honestly. Officials don't usually say, "We are trying to reduce Black political power." Instead, they say things like, "This is about efficiency, this is about reform, this is about improving the system." So, in 1982, Congress changed the law. The focus shifted away from intent and toward results. The question became not what did they say, but what did they do? This bipartisan effort was led by lawmakers including Democrats Peter Rodino, Don Edwards, Senator Ted Kennedy, and Republican Senator Bob Dole. Civil rights organizations pushed hard for the change. Congress recognized a basic truth. Discrimination doesn't always announce itself honestly. Sometimes the clearest evidence is the results themselves. John Roberts was not on the Supreme Court in 1982, but he was already part of the debate. After clerking for Justice William Rehnquist, Roberts joined the Reagan administration. There, he wrote internal memos criticizing key parts of the proposed Voting Rights Act amendments. In 2005, during his confirmation hearings to become Chief Justice, senators questioned him about those memos. Senator Ted Kennedy told him, "It seems that you were trying to undo the progress that so many people had fought for and died for in this country." Roberts said he had no issue with the Voting Rights Act as it existed. 8 years later, however, he authored the decision that disabled one of its strongest protections. The debate Roberts joined as a young lawyer would eventually define his legacy. In 2008, the United States elected its first Black president. For many Americans, it felt like proof that the country had changed, that the old barriers had finally fallen. 5 years later, in Shelby County versus Holder, the Supreme Court said that the formula used to determine which states were subject to preclearance was outdated. Chief Justice Roberts wrote,
"Our country has changed."
Justice Ruth Bader Ginsburg responded with one of the most memorable dissents in modern history.
Throwing out preclearance when it has worked and is continuing to work is like throwing away your umbrella in a rainstorm because you're not getting wet.
The rain hadn't stopped. The umbrella was simply doing its job. For decades, parts of the South operated under a system called preclearance. Certain states with long histories of voting discrimination had to get federal approval before changing voting laws. Congress created preclearance because states repeatedly changed the rules to weaken Black political power. They instituted things like poll taxes, literacy tests, district manipulation, election restructuring. The methods evolved, but the pattern remained familiar. Louisiana was one of the states covered by preclearance. So was Alabama. Before changing election laws or district lines, officials had to prove those changes would not harm minority voters. In 2006, Congress revisited the Voting Rights Act. Lawmakers held more than 20 hearings, heard from dozens of witnesses, and compiled over 15,000 pages of evidence. Congress concluded that discrimination had not disappeared. It had evolved. The evidence showed newer forms of vote dilution, such as district manipulation, election restructuring, polling changes, and systems that weakened minority voting power without openly announcing racial intent. Congress found that covered states continued producing disproportionately high numbers of voting rights violations, and federal preclearance was still blocking discriminatory changes before they could take effect. Then came Shelby County, Alabama. County officials argued that the South had changed, that the federal government couldn't keep using decades-old formulas to place certain states under special oversight. In 2013, Chief Justice John Roberts wrote the majority opinion. The court struck down the formula used to decide which states remained under federal oversight. Roberts wrote that the country had changed. Within hours of the decision, several states moved forward with new voting laws and district changes that previously may have required federal approval. The guardrail was gone. The debate was never only about one law. It was about what happens after political power shifts and who gets protected when the rules begin changing again. After the 2020 election, courts and election officials across the country found no evidence of widespread fraud that would have changed the outcome. And yet, many states changed their voting laws anyway. Supporters said the changes were about election security. Critics said they made voting more difficult for some communities, which raises a simple question. If the election was repeatedly found to be secure, what problem were these new restrictions designed to solve? Once again, it seems like a result that some people didn't like occurred, and then they had to change the rules. Louisiana is roughly 1/3 Black. With 6 congressional districts, that means Black voters should have a meaningful opportunity to elect candidates of their choice in about 2 districts. For years, Louisiana had only one majority Black congressional district. When federal courts concluded that this likely violated the Voting Rights Act, Louisiana drew a second majority black district. Then came Louisiana versus Callais. Opponents argued that the state relied too heavily on race when drawing the new district, and the Supreme Court agreed. In practical terms, the court made it harder to preserve districts designed to give black voters a fair opportunity to elect candidates of their choice. The map may not look exactly like it did a century ago, but the core question remains the same. How much political power will black voters be allowed to exercise? Federal courts initially ruled Louisiana's congressional map likely weakened black voting power. Judges said the state may have been required under the Voting Rights Act to create a second majority black congressional district. So Louisiana redrew the map. The new version included a second majority black district. But then opponents challenged the new map. They argued the state had relied too heavily on race when drawing the district lines. Critics said the state had entered a legal maze. If Louisiana didn't create another black majority district, it risked violating the Voting Rights Act. But then if it did create one, it risked being accused of unconstitutional racial gerrymandering. This debate exposed a deeper question. How do courts address racial inequality in voting without making race itself the central factor in drawing political power? (1873), 1920s, 1965, 1966, 1967, 1968, 1969. Different decades, different language, but it's the same pattern. Black political power expands, and the rules changed. Sometimes through violence, sometimes through legislation, sometimes through maps, sometimes through court decisions. But the pattern remains. Many of us were never taught this history clearly. We were taught a simplified version, a version that celebrated progress, but often skipped the backlash, skipped the systems, skipped the ways rules were rewritten to preserve power. So when similar patterns appear in real time, it can feel shocking. Not because it's new, but because we're seeing it clearly for the very first time. Reconstruction didn't end all at once. It was dismantled piece by piece, rule by rule, office by office. And if you're paying attention, you can still see the pattern today. A vote is cast, a choice is made, and then the rules change. Because the deepest fear has never been that Black people will vote. It has always been that those votes will work.